Breaking news out of Washington, D.C. The Supreme Court has announced that it will consider special counsel Jack Smith's request to decide on Trump's absolute immunity in the January 6th case. What does this exactly mean? Let's go in order. You might remember that just a few days ago, federal judge Tanya Chutkan had rejected a motion by Trump claiming an absolute immunity from prosecution for his alleged role in the January 6 events. Trump had then appealed that decision by Judge Chutkan in a motion that I covered in this video. And in this video, I had indicated that that appeal by Trump was a time-waste move designed to run out the clock. And that's because this decision would first go to the Court of Appeals to be decided, and if that appeal was rejected, then the Trump team would have an opportunity to go to the Supreme Court, adding more time to a trial that is supposed to start on March 4th. Well, special counsel Jack Smith decided to leapfrog the system essentially through a move that is very seldom used, requesting that decision to be made directly by the Supreme Court, skipping the process that goes through the Court of Appeals. Court procedures allow for this, but it's a little bit of a nuclear option because Jack Smith has to prove that this is essentially an unprecedented situation. He must prove that the harm done by waiting until the Court of Appeals decide and then eventually the Supreme Court decide would cause irreparable and sizable enough harm to the situation overall. And obviously, Jack Smith struck a chord with the court because they did respond to the motion, and he did so by bringing up an event where this specific procedure was also used, and that is the Watergate. So now the Supreme Court has reviewed this request and said, yeah, we'll consider that, and gave the Trump's team until December 20th to respond to that motion. This doesn't mean that the Supreme Court will necessarily hear the case and then decide on it. They simply said, yeah, Jack Smith, you made enough of a case that we will consider leapfrogging the system and hearing the case without first going through the Court of Appeals. Well, everything is still undecided. We don't know if the court will hear the case. We don't know if they do what they will decide. And we don't even know if all of that happens, whether there will still be time to have a March 4th trial as it is currently scheduled. Well, all of this is still very uncertain. This is certainly not very good news for this guy.